We're ready to hear argument in 19-459, Bluestone Natural Resources against Randle from Hood County and the Second Court of Appeals District.
May it please the court, Ms. Weber will present argument for petitioner. Petitioner has reserved 5 minutes for rebuttal.
Ms. Weber?
May it please the court. For decades, it has been a fundamental rule of Texas oil and gas law that if a lease provides for royalty to be based on a value at the well, then post-production costs must be deducted to properly compute and pay the royalty. And in Burlington, the court clarified and refined that rule by articulating a distinction between evaluation point and evaluation method, and confirming that each has equal dignity and each operates independently as part of the royalty computation. The court in Burlington confirmed that a proceeds type royalty valuation method does not trump an express at the well valuation point because they address different things. And when the parties specify that an at the well valuation point, the royalty holder must share in post-production costs regardless of how the royalty is calculated.
Ms. Weber, have we ever said that at the well trumps gross the point of sale? So at the well net trumps gross the point of sale? Because I don't think gross was an issue in Burlington, was it?
No, Your Honor, that's true. This court has not addressed the direct tension between those two concepts. But there's a good reason for the fact that the court emphasized the equal dignity of the valuation point and the valuation method, because an at the well valuation point is not just an accounting detail. It's not just a totem. It's not talismanic. It reflects that the parties have bargained for a royalty to be based on raw gas as it comes out of the ground, as opposed to a refined downstream product that whose value has been enhanced by transportation or processing. And that's the why of the emphasis on the independent operation of an at the well valuation point. And the court described it this way in Burlington, in something that was echoed since Heritage through the years, the Fifth Circuit in Warren, that allowing the holder of an at the well royalty to escape his responsibility for post-production costs would improperly convert the royalty interest from a royalty on raw products at the well to a royalty on refined downstream products. You're talking about a different product when you move away from an at the well valuation point.
Is there any? Go ahead, I'll ask after you're done.
The Court of Appeals ignored the clear mandate in Burlington and held that what it called a pure proceeds valuation method, one that is not tied to a particular point of sale, conflicts with an express at the well valuation point and trumps it. And that's the exact opposite of what this court said in Burlington. And it's true that
that's what I was going to ask you, is what language in Burlington supports your position that gross does not conflict with at the well? I didn't know what language you might be looking at.
Well, the precise language is when the parties specify an at the well valuation point, the royalty holder must share in post-production costs regardless of how the royalty is calculated. That language, Your Honor. That language followed up by the recognition by the court that at the well valuation is a distinction not just in an accounting issue, but in the product that's actually being sold. You're selling raw gas at the well, you're selling a different refined value enhanced product if it's at a downstream point. And that's the language in Burlington. And in evaluating whether there's a conflict between those two concepts, the gross value received versus at the well valuation point, in evaluating that, there are a lot of general contract interpretation notions, but also particular to this court's jurisprudence on this post-production cost issue that I think are helpful. there's the general notion that you view the lease as a whole. The entire thing, the pre-printed portion, the addendum, how they interact, view as a whole, strive if at all possible to harmonize the provisions so that none are rendered meaningless.
Do we
But
view it as a whole if the addendum says that it supersedes the printed lease?
Well, Your Honor, only if there are terms that are conflicting, that are contrary. So,
And would terms that talk about that you're to compute and pay royalty on gross value received, including reimbursements for severance taxes and production related costs?
Your Honor,
But that, I mean, because obviously that's stuff that gets calculated long after the wellhead.
yes,
How do you reconcile the long list of things in the addendum that it says the value is not going to be net of, like storing, separating, gathering, compressing, processing, transporting, or otherwise making the gas marketable?
well, Your Honor, that's another issue in the contract analysis, contract interpretation analysis presented here is in this court's jurisprudence is the reality that sometimes not every express term in an oil and gas royalty provision ends up having meaning. And sometimes express lease provisions pertaining to the proper calculation of royalty are surplusage as a matter of law. That happened in Heritage, where the court held that the precise language saying without deductions for costs and listing those sorts of costs, that was surplusage as a matter of law. The same thing happened in the Hyder case, where in the Hyder case, the court found some language that was surplusage as a matter of law, but also in the Hyder case, the lease there had expressly disclaimed heritage, and the court said that's not meaningful because what we look at is what is the actual measure of royalty, the valuation point, the valuation method. And so what we have here in that paragraph 26 addendum, there are two sentences that are at issue. The first sentence, I think, is the plain is just like the no deductions clause in Heritage. That I think that first sentence, without any deductions for all of those things, I think that is surplusage as a matter of law, just like it was surplusage as a matter of law in Heritage when you have an at the well valuation. The second sentence is really what this case turns on, the meaning of the second sentence. And I'm very glad, Justice Plan, that you focused on the including reimbursement for severance taxes and production expenses, because I think that highlights a difference in this case that turns on the precise language, because the addendum, paragraph 26, that second sentence in paragraph 26 doesn't say gross proceeds. It says gross value received. That's a different phrase than was at issue in the Judas versus Mewburn case. Gross value received. And it doesn't just say gross value received, it says gross value received, comma, including reimbursement for severance taxes and production related costs. Now, reimbursement for severance taxes and production related costs are not common at all value to be received, and they are not, in fact, the sales price, the actual proceeds for the sale. If I sell you 100 MCF of gas, you pay me X dollars per MCF, those are my proceeds. Typically, it's highly unusual for the buyer of gas to reimburse for severance tax, highly unusual for the buyer of gas to reimburse for production related expenses. And so, but those are there. Those are among the precise words that the parties chose to include in this addendum. And they have to animate the appropriate construction of gross value received. And so I submit to the court that those precise elements indicate an intent for gross value received to be not precisely a proceeds. It makes it different from the Judas construct.
Ms. Weber, can you reconcile your melding of the two clauses with the Judas and Heritage analysis? Because Burlington did not overrule either of those cases. And so I guess I'm having a little trouble because the gross value received clause inherently and irreconcilably conflicts with at the well. And so how do you reconcile that you melding the two clauses with our own precedents? Curious about that.
Well, really, I think what it boils down to isn't Burlington versus Heritage. It's Burlington versus Judas, is really what this court has to decide. And I have a number of reasons why this court ought to put greater weight in the Burlington construction that an at the well valuation point remains operative regardless of how the royalty is calculated, and here's why. First, Burlington reflects and evolved and matured jurisprudence from this court regarding the post-production cost exception. Heritage and Judas decided the same day in 1996 were sort of the beginning of this notion of a recognition of an at the well valuation point having independent legal significance. And that jurisprudence has evolved, has matured, has refined over time, and we've arrived at Burlington. And while Burlington didn't say, I overruled Judas, Burlington represents an evolution. I don't think you have to overrule Judas, but I think Burlington reflects an evolution of the jurisprudence. Second, in Burlington, relatedly, the court said expressly, when there's this party specifying at the well valuation point, the royalty owner must share in post-production costs regardless of how the royalty is calculated. You said that, sure you meant it. Regardless of how the royalty is calculated, that's gross value received. Second, another point, Judas involved a single sentence, a highly unusual single sentence in a division order, not in the lease, in a division order. And it said settlement for gas sold shall be based on the gross proceeds realized at the well by you. And there were three different division orders. Two said gross proceeds realized at the well by you, and one said net proceeds realized at the well by you. So what the court had was before it the exact same facts under the same lease, two different structures of highly unusual language in division orders, and found that those two had different meaning and ascribed a meaning to gross. And I think that Judas can be limited to its facts in that regard.
Ms. Weber, I'm sorry to interrupt you, but I'm just trying to understand what you said earlier about the addendum. Are you basically saying that it's superfluous and we shouldn't even look at it?
No, Your Honor, I'm not saying that. I'm saying that in paragraph 26, the first sentence of paragraph 26 is surplusage as a matter of law, just like the no deduction language in Heritage was surplusage as a matter of law, just like the no deductions provision in the addendum in the lease in the Warren case was surplusage as a matter of law. Indeed, at oral argument in the Court of Appeals, Mr. Barton agreed with the court that if paragraph 26 in the addendum stopped at the end of the first sentence, there would be no argument at all that this was any different from Heritage, and it would be at the well, and that would be that.
Counsel, it seems that in Burlington, there was perhaps some tension between the at the well valuation point and the amount realized method, and the court held that the valuation point controlled because it went to the nature of the royalty. Here, though, the parties have in their contract told us what to do if there's tension between their provisions, and we didn't have that or anything like it in Burlington. And I'm struggling to see how we'd be effectuating the intent of the parties by not honoring the choice they made to emphasize the preeminence of the no post-production costs and gross value received clause?
Well, Your Honor, I don't believe there is tension between a no deductions clause and an at the well valuation. That the structure and the question of superseding, that's exactly in the Warren case. There was an at the well provision, amounts realized at the well provision in the lease, and a no deducts in the addendum. So you had the same situation where an addendum is supposed to control, but a no deduction cannot change. That's the fundamental lesson from Heritage. A no deduction clause is surplusage as a matter of law, where you have an at the well valuation, because that's where the royalty is valued. And
I
there
guess
are no
the difference perhaps would be that in Burlington and in Warren, the court is trying to harmonize these provisions that might be thought to be pointing in different directions. Whereas here, the parties have told us how to go about dealing with the two provisions.
Well, Your Honor, I submit to you that they can still be harmonized, that the gross value received can be harmonized with an express at the well valuation point. First of all, it is an express valuation point. And given the independent significance, the operative legal significance of an at the well valuation point in Texas oil and gas law, if you have an express at the well valuation point, in order to change it, you ought to need to have an express change. Express to change express, and not an implied back into it, maybe if you squint at it on a Thursday. So I see my time is up, and Mr. Barton needs to speak, but I think that the court can harmonize these two by looking at the precise language of the sentence in the addendum. Gross value received, comma, including severance tax reimbursement and post-production and expenses of production. What that indicates, that is wholly consistent with that provision acting as a backstop for an iseguirre situation, where you have a mismatch between market value and proceeds realized. And what that does is it mandates that you start your calculation with what the actual value is received, and then you value it at the well, as opposed to the starting point of, say, a market value study, which is what you would often do, and which is what led to the economic mismatch in the iseguirre case. And given the fact that paragraph 26 in the addendum is lifted directly from the General Land Office's Relinquishment Act form lease, where it fits in with an entirely different set of royalty provisions, and it operates in an entirely different construct, it makes sense that there would be a sort of a bigger picture application of that language, and not simply we're adopting Judas. If this were intended to be an operation like Judas, where gross proceeds trumps, they would have said gross proceeds, but they didn't. It said gross value received, which is a different term, which is a broader construct, comma, including reimbursement for severance taxes. And if you back up, and this is a little bit of I want to be an oil and gas theologian for a second here. If you back up, and we submit that is an iseguirre economic workaround, you back up, the iseguirre case involved whether or not the royalty owners would share in the proceeds from a take or pay contract, a long-term take or pay contract that had a contract price that was not tied to market forces, that was substantially greater than the current market value. Exactly the opposite economic situation than the Bella case 30 years before. So in the iseguirre case, it involved a take or pay contract that was the same take or pay contract that was at issue in this court's earlier opinion, Tennessee Gas Pipeline Company versus Lenape. And that gas contract that led to the iseguirre mismatch includes a provision for severance tax reimbursement.
Any
So
other questions? Thank you, Ms. Weber. We'll hear from the respondent.
May it please the court, Mr. Barton will present argument for respondents.
Bluestone's arguments contradict the plain meaning of the lease terms. The addendum requires royalty to be computed and paid on the gross value received. Gross value received is the opposite of royalty valued at the well. Gross value received means that the gas must be valued at the actual point of sale where the value is received. And that's why it can't be reconciled with at the well and is sufficient of itself to preclude deductions for post-production costs. As shown on the handout that we provided the court, Judas and Heritage hold an inherent and irreconcilable conflict exists between the terms gross proceeds and at the well. And even though Judas dealt with a division order, the case reflects that the party agreed that the royalty was governed by the division order. So there's no distinction between Judas and the lease royalty provisions here. Bluestone argues that these irreconcilable and conflicting terms should be merged together to read gross value received at the well. That negates the meaning of gross value received and the superseding clause that stipulates the addendum supersedes contrary terms in the printed form. Bluestone's asking the court to give the at the well clause an elevated all-consuming status so that it supersedes the gross value received clause. The parties agreed to the exact opposite. And the court in Piranha Partners recognizes that clauses in conveyance documents should not be artificially elevated and given greater meaning. Bluestone is asking the court to pretzel together irreconcilable clauses in the addendum and the printed form to hold that the parties objectively intended for gross value received to be net value received.
Mr. Burton, is gross value received when calculated at the well different in amount than gross value received when it is eventually sold at market? In other words, the raw gas that comes out of the land has a particular value, but is that value enhanced when later, beyond the well, all these other things are done, to enhance, refine, make the raw gas suitable for marketing? And if that's the case, why isn't gross value received just a calculation that's done, but done at the time of the well, instead of done much later to what is transformed into something completely different than what the lease produces?
Yes, Your Honor. The reason why Judas holds that there's an irreconcilable conflict between gross proceeds and at the well is because they have opposite meanings. Gross value received is valued at the actual point of sale, and it includes the value that is added up to that point of sale. At the well does not do that. Judas and Heritage hold that gross proceeds at the well is ambiguous. There's no way to know what the parties intended to do by using conflicting terms with opposite meanings. Judas did not harmonize gross proceeds at the well the way that Bluestone is asking the court to now do, because the terms inherently conflict. And here the superseding clause resolves that conflict by saying the gross value received clause supersedes the at the well clause.
Mr. Burton, is Hyder instructive at all, where we said that gross means undiminished by deduction? Is that instructive here as we try to analyze the two clauses?
Yes, Your Honor, it's very instructive. The royalty provision in Hyder was a price actually received, tantamount to gross proceeds. There was a separate no deduction clause. Here we have in paragraph 26, a no deduction clause, and then a separate gross value received clause. Contrary to what Bluestone just argued, what the court in Hyder says is that the no deduction clause can be considered to provide emphasis to the party's intent with respect to the price actually received clause. And if it is considered to be surplusage, it is surplusage to that, not to at the well. And so here, the no deduction clause provides context that the parties contemplated downstream sales. The evidence is that all of the sales have been downstream. And the no deductions clause emphasizes the party's intent that royalty would be paid on gross value received without deduction of any post-production expenses. Judas and Heritage address the word gross. Burlington does not. Judas holds that gross proceeds means gross price received. And again, Judas didn't try to harmonize the phrase gross proceeds at the well. You can't reconcile what is irreconcilable. And this court's jurisprudence in Piranha Partners and other cases recognizes that terms are harmonized to the extent possible. Under Judas and Heritage, it's not possible to harmonize gross value received and at the well. Harmonizing is not proper if it changes the plain meaning of the agreement. And that's what Bluestone wants. It wants the court to change gross value received to net value received. Judas and Heritage were the law when the leases were drafted, and they are the law. If the court were to now hold that there is no conflict between gross proceeds or gross value and at the well, it should only apply prospectively and not impair the myriad of leases that that have been drafted in light of Judas and Heritage.
In Burlington, Mr. Barton, in Burlington, where was the term gross or any other point of sale language used in the lease at issue there? I'm just wondering if Bluestone is maybe advocating too broad a reach for Burlington's language and analysis. I don't think those terms were used there in the lease.
That's correct, Your Honor. Burlington should be read in the context with the terms that were at issue because different terms have different meanings. Burlington did not deal with an addendum first requiring royalty to be paid on the gross value received or on gross proceeds. And it did not contain a superseding clause that superseded contrary terms in the printed form. And Burlington involved a related transaction document that provided for royalty to be paid on net proceeds. That does not exist in this case. There's nothing inherently inconsistent with the words proceeds or amount realized being modified by at the well to mean net proceeds or net amount realized. But Judas and Heritage hold gross proceeds cannot be harmonized with at the well because it inherently conflicts with at the well. And in order to give effect and meaning to the superseding clause that the parties plainly agreed to, the gross value received clause supersedes the contrary at the well clause.
Mr. Barton, I'm just trying to understand, but is anything actually received at the well, it seems like it has a gross value at the well and at the point of sale, but there's only one place where it's received, and that would be the point of sale. Is that correct?
Gross value received is valued at the actual point of sale. Adding,
So if a gatherer ultimately sold the gas before it was processed or refined to someone else, for example, if Crestwood wasn't just the operator, but actually took title to the gas, you wouldn't claim then that those production costs, that they had any bearing on that value. In other words, at the well would be the sale of the raw gas, but you're saying in this case, it's there's not a sale of the raw gas until after processing, and that's why those deductions can't be included in the royalty calculation. Is that right?
I think that's right, Your Honor. All of Bluestone sales have occurred downstream in arm's length transactions. Bluestone can sell the gas anywhere, but the royalty is always paid on the gross value received. If Bluestone were to make a sale actually or physically at the well, the royalty would still be calculated and paid on the gross value received. Bluestone can make arm's length sales anywhere that it wants, and the gross value received is the gross proceeds that Bluestone makes from those sales. The gross value received clause was not required to say at the point of sale in order to supersede the at the well clause. Adding the words at the point of sale adds nothing to the meaning of gross value received. Value received is gross only at the point of sale because it includes the value that has been added up to that point.
So
Any
Mr.
other?
Martin, are you saying that gross value received may or may not conflict with market value at the well, and it depends on the facts of the case? Because if the sale happens at the well, then they don't conflict?
Your Honor, the royalty is always paid on gross value received. If Bluestone
But the
makes a
question
sale,
is, where is the gross value received? And in Justice Bland's hypothetical, she said, what if it's sold at the well?
Yeah.
And so
If
then the value would be received at the well, right?
yes, Your Honor. And,
Okay.
and the royalty would be paid on the gross value. If the sale occurs physically at the well, the royalty is paid on the gross value received. There is no net value, only gross value. From an accounting standpoint, the gross price is what it is, and if it's physically sold at the well, there's nothing to deduct from it.
Well,
To
there
come
would
up-
be
That seems like
pre-production costs and costs associated with the actual production.
The royalty is not subject to pre-production costs.
So only post-production, and there would be none at the well if the sale
That's
happened at the well.
So,
That's correct.
so the question was, if Bluestone sold the gas at the well, then there would not be a conflict between gross value received and at the well.
There is no, to the extent at the well means net. There just is no net if it is physically sold at the well.
Well, so
There is only the gross price received.
so there would be no conflict.
It would still be paid on the gross value received.
But there would be no conflict between that number and the number at the well. It would be the same number.
Yes, it just from an accounting standpoint, there is no net value received.
So one of the arguments is that the addendum conflicts with the printed lease, but that would only be true for downstream sales.
And all of the sales occur downstream.
But that's not required. That's just what was selected in this particular case.
I beg your pardon, Your Honor?
Well, nothing in the lease requires that the sales take place at a certain point, right? Or I mean, that's just what happened here. They could have sold it at the well.
Yes, that's correct.
So that seems like an unusual. What do we do with a lease like that where the provisions sometimes conflict and sometimes don't, and it depends on the facts?
Yeah, and I think the answer to the question, and I probably did not articulate it well in answer to Chief Justice Heck's question, the concept from a legal standpoint of gross value received at the well, given legal meaning to those, is, as Judas and Heritage says, they have opposite and conflicting meanings. And so the terms themselves can't be harmonized. So under this lease, to give effect to the superseding clause, because gross value received is the opposite and inherently conflicts with at the well, the gross value received clause supersedes it. Supersedes means it takes the place of it.
Mr. Barton, can I just ask you before you run out of time about the free use clause as applied to compressor fuel? What contract language do you think constrains the free use clause to on-premises operations? And is there any evidence in the record that we can determine whether the lessors are owed something for their allocated share of the commingled gas?
Right. The leases, Your Honor, allow Bluestone to use gas produced from the leases for its operations hereunder the leases. Operations hereunder means operations thereon the lease premises. If you go up to the granting clause in the leases, it grants Bluestone the right to engage in activity thereon the lease premises. Obviously, the lessor can't grant rights for Bluestone to engage in activities on someone else's property. Because Bluestone commingles the gas, Bluestone has the burden to prove what portion of our gas is used off lease to benefit other leases. And because Bluestone can't prove that, royalty is owed on all of the value or the volumes of gas that is deducted from Respondent's production. If those volumes had not been deducted, they would have been sold and royalty would have been paid on the gross value received. And I do want to point out or correct one of Bluestone's arguments in its brief. The compressor fuel numbers are based on a volume of gas that Bluestone deducts from our production. Contrary to what Bluestone says, it is not the value of our gas used for our compressors. Because of the commingling, Bluestone can't prove what portion of our gas is sent off lease to power compressors on other leases. And the free use clause just does not allow Bluestone or anyone else to use our gas to process other lessors' gas or to run compressors on leases for the benefit of other lessors. The commingling requires Bluestone to be liable for all of those volumes of gas because it cannot prove how much of our gas is being used off the lease premises.
Any other questions? Thank you, Mr. Barton. Ms. Weber, I believe you have 5 minutes.
May it please the court. I would like to make 3 brief points in rebuttal. First, Justice Guzman, regarding your question about the free use clause. The language in the lease that allows free use says that it may be used for all operations which lessee may conduct hereunder. And there we've cited a number of Texas cases and cases from other courts that exact language and language just like it, functionally equivalent language, allows exactly the kind of use that's an issue in the plant fuel and the compressor fuel, that the phrase hereunder or thereon refers not to the physical location, but refers to the purpose of the use. Is it for furtherance of the operations of the lease? And the answer here is yes. And actually the compressor fuel is used on the leases. It leaves and then it comes back. The compressors are located on the leases, so there's not even a location disparity. And as far as the question of have we, Mr. Barton said that we can't prove what portion is used on each lease. Well, we
the molecules are fungible. That's what's getting a little difficult in the analysis, because commingling shouldn't be an issue if proper allocation has been made. I'm trying to understand.
Well, proper allocation was made, Your Honor. That's what we stipulated to. If you look in the party stipulation and the final judgments, what did everybody think they were stipulating to? It's the plant fuel. What's the judgment says for plant fuel, you get this number of dollars down to the penny. The plant fuel is the allocated amount that's used for the plant fuel, and the compressor fuel are the specific allocated. There are meters everywhere. On every juncture, there's a meter. Everybody knows, and all of that resulted in stipulations. And the court ought to the precise issue here, but backing up a second. First of all, we stipulated to it, so factually we did prove it, and they agreed to it. But second, more important, that's a damages question, if you will. We need an answer to the bell cow question, the threshold question of, can compressor fuel come within the scope of the free use clause? Because that's a separate declaration in the party's judgment. The parties need to know that on a going forward basis. Can we do it or not? And then the second question, if we can't do it, what are the dollars, the extra additional dollars that we owe them? The stipulation issue is the part 2 question, additional dollars we owe them. But whether or not we have successfully and accurately established their aliquot portion doesn't tell us whether or not it's a threshold matter. Can we do it or not? Is this within the scope of the free use or not? And it is.
Turning back to the gross value received, what weight or any effect should we give a course of performance of the parties into this lease, where
0.
For a number of years, gross value received was calculated according to the way the lessors say that it should be calculated, which is free of post-production cost deductions?
You should give that 0 weight for factual and legal reasons. Factually, the prior operator, Quicksilver, owned the gathering system. And so there were not costs. One of the differentials, one of the costs that Bluestone deducts was not a cost that Quicksilver incurred. And so it was a factually different situation of what was there to deduct or not deduct. And legally, just because the interpretation of this contract depends on its terms, irrespective of what happened in the past. So the fact that costs were treated differently in the past is of no moment. I'd like to close out with the point that there's an express at the well provision. And if the parties to this contract wanted to change that express at the well valuation point, they needed to say so. And they did say so. They did make certain express amendments in the addendum where they really wanted to change a particular term that was in the printed lease form. Paragraph 14, they expressly said, we amend the 1/8 royalty fraction to be 1/5. Paragraph 16, they said, we expressly amend to make it not oil, gas, and other minerals and make this lease cover hydrocarbons only. And if they wanted to have an express change of the point of valuation, they needed to say so, and they didn't. And we request that the court respectfully urge the court to reverse the Court of Appeals and render judgment construing the lease to provide for an at the well valuation point.
Any other questions? Thank you, Ms. Weber. The case is submitted and the court will take another brief recess.
All right.